WHPR TV is now on demand. Catch us when you want, how you want, where you want. 24 hours a day, 7 days a week. Watch your favorite TV shows on demand. And be sure to download the WHPR app. We're now on demand at your demand. WHPR TV Detroit on demand.com. A Watkins.
Good afternoon and welcome to Law Power Hour. Today I have an exciting, interesting opportunity for all of us. I have Christine Longstreet with us. She's a public defender. She works in Wayne County. She's here to answer questions. So I hope you call in and ask questions because she's one of those individuals who's dedicated her life so far in her professional career to helping those in the community who can't afford a lawyer for criminal defense. Christine, thank you for coming aboard today.
Thank you for having me.
You know, it's really interesting to have a practice devoted to criminal defense. How did you get involved in this?
So I did an internship at the Legal Aid and Defenders Association. It was a summer that I spent working on an appellate case. And that just started my love for it. I actually only worked on one case, People versus Fisher. At the time, it was one of the longest running murder cases in the sense that it had been up to the Supreme Court and back, up to the Court of Appeals and back. He had been convicted, and it was just so interesting. Most of what I did all summer was catalog information from 4 prior trials.
Now, the majority of your work, is it done in Wayne County?
100%, yes.
And what kind of cases do you handle at the present time?
I handle everything from possession with intent to deliver or marijuana to up to felony murder cases.
Now, how are clients assigned to you in the defender's office? This is something I've never understood.
So let me just back up. The Legal Aid and Defenders Association, the State Defender's Office, gets approximately 33% of the felony criminal cases from Wayne County Circuit Court Criminal Division. And that is by court order or administrative order. The other 70% or so, 75% of the cases are assigned by the judges on a rotating basis. In our office, there are 14 attorneys who represent clients or defendants from initial preliminary exam to trial. And we have someone who is assigned a supervisor who looks at the case and assigns the case to individual attorneys based on caseload and experience.
Now, in terms of experience, in order to handle a felony murder case, you have to be approved by a special committee because not every attorney is permitted to handle a murder case. Isn't that true?
That's true. There is the Wayne County Criminal Advocacy Program. All lawyers have to go through that, and then to make it to a list where they can receive assignments for what we call capital cases, any cases involving any number of years up to life in prison, they have to have been properly vetted.
Now, in terms of the number of cases that go through the Frank Murphy Hall of Justice, that's where you spend the majority of your time, isn't it?
It is.
How many cases a year go through Frank Murphy Hall of Justice with appointed lawyers, combination of your office and those 70% that pass through the system?
I would say that probably almost 85 to 90% because the system that Wayne County uses is when a person is charged with a offense, a felony matter, they're automatically assigned counsel. There's an assigned counsel's office. They alert the individual that there's an assignment, and that individual either accepts or rejects it, and then it proceeds on from there. And maybe, just experience, maybe 10% of those individuals eventually end up retaining counsel, paying for their own lawyer before they start in the process.
Now, on the assignment basis, you said about 70% of the individuals who were assigned are assigned by attorneys from the various judges on the bench, correct?
Right.
Is there an order that the judges must follow, or can they just select out of the group of attorneys in their pool?
So there's one large pool, and the judges pick the lawyers individually. But the one caveat is that the lawyer has to be a part of the CAP program. They have had to have participated in at least 6 seminars if they've not been practicing 10 years or more. And then they have to be a member of the Wayne County Criminal Defense Bar Association.
What is the CAP program?
The CAP program it begins in September, and it is a series of seminars that occur on Friday, usually at about 1, and there's approximately 14 seminars, and the lawyers can pick between the 14 which ones they want to attend. There's always a Michigan criminal law update. There's always a Supreme Court update, and then there are different seminars, if you will, based on people's prior responses and suggestions made by the lawyers in the CAP board, the Criminal Advocacy Program Board.
Now I'm going to ask you a question. It's a difficult question. I don't want you to get angry with me, but I have to ask you this question. Do you feel that your office advocates with more vigor in terms of representing individuals than those attorneys who were assigned by the judges?
Well, okay, so it's sort of a loaded question, and let me just answer it this way. I know, most of the lawyers who practice in Wayne County. I've sat in courtrooms, I've watched them, and I'm sure they've watched me. And I believe that if you're on assignment list, whether you're at my office or you're taking assignments, those lawyers do it because they have a passion for the work. And let's be honest, if you're not passionate, you're working in a public arena. So, if you don't know what you're doing, the judge is gonna know about it. Even sometimes the deputies can tell, who's, up to stuff. So I think that the system in and of itself sort of vets out those people.
The reason I ask this question is that we participate in programs for expungement.
Yes.
And oftentimes we see individuals who should have been given the opportunity for expungement for first-time offenders who've never had that discussion. So I began to wonder if they're just being pled out indiscriminately without any opportunity to have that afforded to them, whether it be 4711, whether it be Holmes Youthful Trainee, or some of the other deferral programs that are available.
Right. And so, I'll be honest, there's good and bad in every profession. And my standard or my level of diligence may not be the same. Sometimes you have to go that extra mile. Sometimes you have to stand in a hallway and convince a client that they need to come back to court maybe 2 or 3 times, because it makes a difference between whether they end up with the felony record. And a lot of these individuals are young African American men who don't maybe understand the significance of it until they're denied employment, until they're denied housing, or they want to go to college. There's so many economic impacts as a result of felonies, right? And so, yes, I I absolutely 100% have seen it. I've seen it where you have a young man who is charged with a gun charge, right? And he had a gun because, he's scared, he's been to 4 funerals, et cetera, et cetera. I'm not minimizing that, but he's also now facing a 2-year felony firearm charge because he's a felon in possession. And I'm looking at the kid's record and I'm saying to myself, no one tried to get you a disposition that prevented this first felony.
They don't want to write a letter to the gun board.
Well, and sometimes they don't. It's hard to speak on all the things that transpired in a case prior to me meeting an individual, or ex post facto when they're at an expungement seminar and they say one thing, but what I do find is a lot of individuals, they've been through the system and they don't understand the system. I meet a lot of young men who say, I don't have a felony on my record. I finished probation. Well, it's not that simple, right? And so sometimes the sheer volumes prevents some of the lawyers from really communicating and educating their client.
Now, do you believe in cooperating with law enforcement if law enforcement wants to sit down with your client to determine what the facts are?
It depends, because just because law enforcement wants to sit down, it might not be what's in my client's best interest. And best interest might not just be the deal that's on the table or whether or not they get probation or a lighter jail time or they come home earlier from prison. Because remember that a lot of times individuals, cooperation sometimes mean you have to, get in a witness chair and raise your hand and promise to tell the truth in front of a whole audience of people who are from the neighborhood you are from. And if anybody believes that the Wayne County Prosecutor's Office or any other office for that matter sends people back to neighborhoods under witness protection, it's not happening.
No, because people legitimately have a right to fear the reprisal
Right.
that can occur in the hood.
Yes, in their own community, yes.
Right. So I understand exactly where you're coming from. Now, let's say you're representing a juvenile, and I'm sure some of your cases involve juveniles,
Yes,
where they're trying to bring them over and charge them as an adult.
yes.
Do you want the parents in on those conversations to help make decisions?
It would be in a perfect world, an ideal world, but the reality situation, if you have a juvenile who has been what they call waived over to felony criminal court, that's because the charges are 9 times out of 10 pretty serious and pretty substantial. And so sometimes it's difficult to get the parents on the phone. Sometimes you're at court 4 times and you've never met a parent. You've met a younger brother, you've met a friend, you've met a cadre of girlfriends, but no parent. And that is, one of the things that is, sort of, I don't want to say inherent, but there's sort of like this cocktail or formula that creates a defendant. And when I say that, I'm talking about young males.
Okay, we're going to take a break for a minute. When we come back, we're going to talk about that formula
Okay.
because it's real important to identify.
Okay.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. Know your rights. Watch Law Power Hour, hosted by Barry Keller, attorney at law, Tuesdays at 5 p.m. here on WHPR, Detroit Live.
So you were telling me something really, really interesting that I want to share with our audience. I want you all to pay attention to this because you may find this in your own house and you better be able to identify it. What's that cocktail you're talking about?
So first, let me just say this, that for the majority of individuals who are found guilty and plead guilty, they get something that's called a pre-sentence report. And that's something that's done by probation or the Michigan Department of Corrections prior to a sentencing. And in that report, you get to see what their life circumstances are. And so for a lot of defendants, you got, the first thing is they've not finished school. They oftentimes say, they left school at 10th grade, but conversations, looking at writings and things like that would suggest that their grade level is probably middle school, right?
And don't you believe that the state of Michigan and the Detroit Board of Education is responsible for them leaving school?
I believe, well, that's a that's not just a yes answer. Yes, in some circumstances, but you also have sometimes absentee parents. You know, just in the last question, you said, is the mother there? Well, for whatever reason, a parent can be absent because they have to work 50 or 60 hours a week just to make, rent, right? Or they can be absent because, they themselves were young mothers and they're not, sort of parenting. To double back to the point you made about the Detroit Board of Education and the school, one of the things is that there are not any schools in these communities anymore. Most of these kids don't walk up to the street to school. They have to make their way, throughout the city to get to a school that's halfway away. So there's no community. The other piece of it is this sort of frustration. Okay? And so when I say frustration, a lot of my clients, they will feel like, it's easier for me to relate it in sort of like, to give you an example. I have many clients who have been robbed, right? And the police were called and never came, right? So what does that do to their psyche? What does that do to their perspective? That tells them, this is no big deal. I've run into a lot of kids or clients who have robbed people, shoved guns in their faces, and stole cell phones, $20, pizza boxes. And when I tell them you're facing prison, they can't even believe it. Because like, I've been robbed for 5 times, right? Nobody caught them, or their friend got caught and they didn't even bother coming to court. So they don't understand the significance of the criminal behavior in the very thing that they're participating in.
Well, that in and of itself is a problem because there's a lack of public information.
Yes.
And without having public information to understand the consequences, lots of bad things happen. I represented a young fella in Oakland County, and he and his buddy called up the pizza delivery man. And when the pizza delivery man came, not only did they take the pizza, they took his money and they beat him up.
Right.
And they all served time in Jackson Prison, which, as you know, is the beginning of the end, because then when they come out, they can never find a job.
Right.
And it's very difficult with an armed robbery where there is a serious injury to get an expungement, because the expungement's discretionary.
Right.
It's not an obligation that the court has. It's not mandatory that they grant an expungement. Consequently, when they apply for a job, they've got to check the black box, and they never get a chance.
Absolutely.
So what do you do when you represent a person like that to save their soul and save their hide? Tell me what you can do.
Well, the first thing, you hold the prosecutor to their proofs. You make, because one of the prosecutor's job is to prove that this individual did something and that they're guilty. Right? It's not my job to prove the case for them.
Hold on, we have a question coming in.
Okay.
Good afternoon. I guess that question went by. They'll come back to us. Go ahead.
So the first thing you do is make sure that the prosecutor has all the evidence, because sometimes what they think they have is not what they have. And then the other thing that is
Well, give me an
interesting.
example of what you're talking about there.
So a prosecutor could say, "Well, I have a witness who said that they saw, your client do A, B, and C." Right?
Okay, we'll talk about that witness in a second.
Okay.
Good afternoon.
Good afternoon. Wonderful guest today. If she takes clients, could she possibly put her contact information up? It's not up on the screen, and
Well,
think
I don't know if
some
she
of
can
us
take
really
clients
use
or
her,
not,
So
because she's in the,
thank you. Thank you for coming on, ma'am.
okay, she's in the defender's office. I don't know if
Okay,
she can
thanks.
take
Thank
clients. Okay, thank you. You can't take clients, can you, in the defender's office?
No, I can only take the clients that are assigned to me. That is one of the things that, we're not allowed to do.
Okay, now let me get back to the story you were telling me about having all the evidence.
Right. So sometimes the evidence is knowing the witness, right? And when I say know the witness, a lot of times people have to understand that if they believe that a defense attorney has a lot of cases and that person is overwhelmed, in Wayne County, the prosecutor has just as many cases, right? And there's one of them, and there may be 10 cases on the call that day. So they're meeting sometimes victims 10 minutes before the case is called, right? So I always say that as a lawyer, you have to use every advantage that you have. So one of the advantages you have on that day, you might have two clients that you've talked to ahead of time, right? Because oftentimes the prosecutor's office won't have a witness come down ahead of time. They have them come down when it's time for them to, swear oath and give some testimony, right? Unless it's a fairly serious case like a homicide, but even for armed robberies, because a lot of individuals, they're working, they can't afford to take off and come down to court. So one of the things that prosecutors often say, yeah, the witness is here, great, put them on the stand, because I know that I maybe have Facebook evidence. I have text messages. I have recorded phone calls. I have the neighbor next door who has information that the prosecutor doesn't have.
Hold for a second. Good afternoon.
Well, yes, I'd like to ask a question.
Please.
I'm watching your show right now, and my question is on expungements. I personally have a friend who has a felony maybe about 20 years ago, and I wanted to try to encourage him to try to get that expunged, even though he's self-employed. I'm pretty sure that does trying to limit his employment. So my
Here's what you
question
can
is,
do.
where can he go for services for expungement? What is the process?
I'm going to
How do
explain
you
that
begin
to
the
you.
process?
Here's
And the
the
second
process.
question I have is, I know people with 2 felonies and nothing can be done to help them. But is there any hope for a person who has 2 felonies and they have had no history at all of any type of criminal behavior?
On the first note,
Hello?
we recommend, can you hear me?
Very lightly.
Okay, well, I'm speaking as loud as I can. On the first note, you go to iChat, ICHAT, and pull up the criminal record. After you pull up the criminal record on iChat, you may fax the criminal record to my office, 248 335 6128. I'll repeat it, 248 335 6128. When you fax it,
Okay.
send along the telephone number so I can return the call, and I will review it and tell you whether it can be expunged. If it can be
Okay.
expunged, I will send you an expungement kit with directions, and if you have a question, I will send you my telephone number and walk you through it. Because we do
All
not
right.
charge for expungements, we assist people in getting back on their feet.
Okay.
On the second
Well,
note,
thank you very much.
if you have 2 felonies, there is no help for you with 2 felonies unless you can get a pardon from the state. And that's the only way to go, is you have to get a pardon from the governor. So thank you for calling.
Okay.
Good afternoon.
First of all, thank you very much, both of you, for all the work that you're doing. I just have a quick question, and it deals with clientele transferring from actually working with private attorneys to getting one from the public defender's office. I know a lot of people have been in situations where they, for lack of a better way of expressing it, ran out of money with the attorneys that they hired. Is it possible? What is the process that they can go from that point to actually getting a public defender? Do they just simply terminate the relationship with their attorney and go to the public defender's office, or what exactly is the process?
So the process, well, first of all, the lawyer has to withdraw. So they have to get in front of the judge who is assigned to the case, and the lawyer either has to withdraw or they have to explain the situation to the judge. And I'm going to be honest with you. I've seen some judges say that that is not a good reason for the lawyer to be removed from the case.
Okay.
And so but the system wants the parties to be able to communicate. And so if you're not paying someone, then that could be a barrier to good representation. Not for all lawyers, but for some. And so most of the judges will give the individual appointed counsel. But it's very important to be timely, because one thing judges do not like is 2 days before trial and you're asking for assigned counsel.
Understood. Yeah, that makes perfect sense.
And if there's a breakdown in the communication between the attorney and the client, you must bring that to the court's attention.
As soon as possible.
Understood. Well, thank you very much, both of you.
Thank you.
You're welcome.
Well, we're going to take a break for a minute, and then we're going to come back to our question.
Okay.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. Know your rights. Watch Law Power Hour, hosted by Barry Keller, attorney at law, Tuesdays at 5 p.m. here on WHPR, Detroit Live.
You know, a few minutes ago we were talking about holding the prosecutor to their proofs. Would you explain to our audience exactly what you mean in a criminal case is the responsibility of the prosecutor and holding the prosecutor to their proof? What is the burden of proof? What does it mean?
The burden of it means that the prosecutor must prove at a trial that the individual that they charge with a crime is guilty beyond a reasonable doubt. And there's a number of different examples a lot of lawyers use to sort of explain what the prosecutor's burden is. And one of the things, a lot of times lawyers will say, well, to a jury in voir dire is, well, if I hand you something and say that this is a cake, right? But all it is flour and sugar, and it doesn't taste like a cake, is it a cake? And so there's so many different elements to different crimes, and the prosecutor must establish on each one of those elements beyond a reasonable doubt, that they must prove the elements beyond a reasonable doubt. And sometimes it's just not a matter of I have a witness that will say this, but it's is your witness credible? You know?
So what you've just said is that each crime has its own recipe.
Yes.
And because each crime has its own recipe, there's a number of elements that must be established.
Right.
Do you go through all those elements with your client?
I do. I think it's important that they understand. One of the things that I think sometimes maybe other lawyers don't appreciate the need to do is really make sure that their clients understand what's required of them, but what's required of the prosecutor, because it helps when a client is going into trial. I mean, they're facing, a lot of times maybe prison time, incarceration, or even jail time. But that said, it's important that they understand what the prosecutor must show. But not only what the prosecutor must show, it's one thing to say that the prosecutor must prove something. But just because a prosecutor says they think they can prove it, it's incumbent on the lawyer representing the defendant to be sure that they know that the prosecutor can prove it. And the only way to do that is to talk to your client and investigate. I cannot stress that enough.
Now, you talked about Facebook, talking to the neighbors. How do all these factors play a part in your investigation?
Well, so one point, more recently, there was a case that was set aside, a conviction that was set aside, because nowadays everything has geotags or this metadata, and especially for Facebook. So there was an individual who claimed that he was somewhere else, right? Traditionally, you if someone says, I was somewhere else when this thing happened, well, how do you establish that? Most of the time, it's calling a witness, right? Now, in this age of video and data and everything else, he had taken a picture somewhere else, right? And when he took that picture, it tagged where he was, and it gives it a digital footprint. So that's one of the things that can help. And so one of the things that I can't stress enough is most cases don't go like the O.J. Simpson case. They're not 10 different lawyers, the leading expert in this, the leading expert in that. Most cases come down to cross-examination. But, you can help yourself. You can help your lawyer by talking to individuals in the neighborhood. Or if someone claims you were somewhere, ask them, hey, do you remember us that day? And communicating with your lawyer. A lot of times I'll meet a client, and if they're out on bond, sometimes I can't find them till their next court date. And I understand a lot of times people have phones, government phones, etc., and they only have so many minutes, and once they're down, but it's important that you communicate with your lawyer, because that will help toward the investigation, and it could help toward exonerating you, or it could help toward getting you a reduced sentence, because sometimes the result is maybe it's not a not guilty, but it's something lower on the spectrum that everyone can live with.
Okay, that's a delicate balance that I want to talk about. You're defending a criminal defendant. He's charged with larceny in a building. Tell us what larceny in a building is, because I have specific reasons for asking you these questions.
It's when a person enters a building and they steal something inside.
Okay, so let's say that individual's over at Macy's, and they're over in the polo department, and they walk out with 4 pair of pants. Total value's $350. It's a felony, isn't it?
Yes.
They haven't left the store yet, but they're walking around with them. And they're not in the pant department, but they're up in the furniture department.
That's not a crime.
They got a bag under their arm. They're putting the pants in the bag and getting ready to exit the store.
Okay.
That's a crime, isn't it?
Yes.
Okay. Now, the person who follows them around the store catches them as they're putting the pants in the bag. Is that larceny in the building, or is it an attempted larceny in the building?
If you ask the Wayne County Prosecutor's Office, it's larceny in the building. I believe it's closer to an attempt larceny in the building. Uh, and and it could even be when you say they catch them. What does that mean? They stop them. There's a struggle.
They stop them. There's no struggle. They stop and say, "Hold on here."
That's I would argue there's no larceny. Where's I mean, you have to show that they intended to take it, right?
Now I'm going to hit you with the hard one. They offer you a plea to attempted larceny in the building. Are you going to take the plea, or are you going to go to trial?
I think it depends on. So that's a question that depends on a lot of things. It depends on their circumstance. It depends on your client's level of comfort with risk taking. Because if a client doesn't have a prior record and you're going back and forth as to what his intent was, whether he was going to put it in the bag and walk back downstairs, and he's in front of and he has a friendly venue where if he goes to trial, he's going to end up with a larceny in a building if he's convicted and not the attempt, but he's still going to end up with a felony. That's the thing. A lot of times clients want you to give them one answer, but there is no one answer because it involves so many different things.
That's the dilemma for the client.
Right.
But there's also a dilemma for the lawyer, isn't there?
Right. And to be honest, the harder questions for me are when you have a client who's facing and I see this a lot in Wayne County, assault with intent to murder, which is a charge that could send someone to prison for a very long time.
20 years?
Depends on their record, but you're starting at, if it's like someone says he pointed a gun and he fired a shot at me, you're looking at maybe 10 years, right? But the prosecutor makes an offer and your client is adamant, this guy is making it up, and the prosecutor's office recognizes that they have some problems with their case, but they don't recognize that it's such a terrible case where they're pleading it down to probation, but now they're offering you 2 years in prison or 3 years in prison. And so those are the tougher calls because you got a client who could be home in 2 years or 3 years. But if they go to trial and they lose, then they're facing 10 years because the guidelines are what the guidelines are, at least up until about a year ago.
Okay, well, we're going to talk about guidelines here in a minute because guidelines are always an important factor to discuss. Whether you're a first offender or a third offender, guidelines are important, especially in light of the recent case law.
Right.
Let's talk about this individual for a minute, though. First-time offender, takes a plea to 2 years.
Mm-hmm.
Let's say they're 18 years old.
Mm-hmm.
Do you believe they're going to learn a whole new skill set in prison that's going to make them a better criminal when they come out? Are they going to really be rehabilitated?
No, prison doesn't rehabilitate anyone. I mean, you the statistics show that, right?
Right.
Right.
Because the recidivism rate for first-time offenders, that means the returning rate back to prison,
Right.
is about 60%, isn't it?
Or higher in some cases.
Right. Consequently, don't you feel that we're better off taking the risk and taking that client to trial?
I always feel, for the most part, that it's better to go to trial, right? Just because I know the system, especially in a system like Wayne County. But that being said, it's ultimately up to the client, and it's a fine line between advising your client and telling them what to do, because you better believe the advice you giving advice that they follow is one thing, but if you tell them go to trial, in their mind you're telling them go to trial, you're going to win, right? Because that's what they're hearing. My lawyer's saying go to trial. Well, why would my lawyer tell me to go to trial if he didn't think he could win it, or she didn't think she could win it? So that creates sometimes a false confidence.
Now, when you get into that gray area, whether you go to trial or you don't go to trial, and there's a sentence involved, and making the decision, clients often ask, how much time am I going to serve in jail if I take a plea? You're not the guarantor of how much time they can serve, are you?
No.
But you can give them what the probability is, can't you?
Yes.
And how do you make that decision?
I think in Wayne County we may be a little bit more of an advantage because the judges are more willing to give you what's called a Cobb's evaluation. A Cobb's evaluation is simply where you go to the judge and say, listen, I don't have a deal worked out with the prosecutor, but this is what I believe the guidelines are. And if he pled guilty, what would your sentence be? And this is in advance of your client ever uttering one word toward a guilty plea. And so 80% of the judges in Wayne County will do that.
Okay, that's People versus Cobbs.
Right.
And you're entitled, if you're going to take a plea, to get an assessment by the court to at least give you a range if everything that you tell the court is true.
Yes.
Even if there's a prior criminal record and you tell the court there's a prior criminal record.
Yes.
And they're going to go to probation, they get in their background, check it all out. If everything's true and they say, well, you're going to get 18 to 27 months, by
Right.
way of example.
Right.
You got to tell your client that.
Right.
You should put it in writing.
Yes.
Always put it in writing
Right.
so that the client can take it home and think about it.
Right.
And then, do you have to explain to the client at that point how the scoring works for sentencing?
Yes. You really should have had that conversation prior to getting into any discussion with the judge, because what you're saying to your client is, I'm going to the judge. If you want to consider a plea, I'm going to ask the judge to consider giving you this sentence. But the good thing about the People versus Cobb's evaluation is that if for some reason you return to sentence and the judge cannot honor their Cobb's, you can start all over.
Okay. When we come back, we're going to talk about sentence scoring
Okay.
because it's very different today
Yes.
in light of the cases that were decided in 2015 than it was prior.
Yes.
Call in with your questions.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. Know your rights. Watch Law Power Hour, hosted by Barry Keller, attorney at law, Tuesdays at 5 p.m. here on WHPR, Detroit Live.
Okay, so we were talking about scoring a sentence.
Right.
Tell our audience in every criminal case why there's a score used for determining the amount of time a criminal defendant may spend incarcerated. And I use that in its loosest context.
Right.
Okay.
So, and this, I have to say, was a little bit before my time, but it was, there's something called the Michigan Sentencing Guidelines. And the thought behind that was that you had judges giving individuals different sentences for the same conduct. Meaning you could be in front of one judge, same crime, similarly situated, and you get no jail time. And then you're in front of another judge, and maybe you get sent to prison for the same conduct. And so the thought was that maybe that wasn't necessarily fair. And so the Michigan sentencing guidelines takes into account an individual's prior record, their prior juvenile record, misdemeanors, whether or not they're on probation or parole at the time of the offense, whether or not they're more than one charge in a particular case, and then they take into account the actual offense variables or what happened in that particular case. And you look in a book, you tick off points, and then once you come up with the points, you go to a particular chart in the book and you come up with a range, a minimum and a maximum that a judge should give, and a minimum and a maximum that a judge should give if he's going to sentence someone to incarceration. And you also get a guideline score that says because this person is in this range, you should not be sending him to jail or prison.
Okay, let me stop you there for a minute. Now we go into the historical background first. Prior convictions are important.
Yes.
Juvenile records important.
Yes.
There are points for each.
Yes.
Whether this is a single offense or it's a multiple offense, in other words, several counts under one offense.
Right.
If they're, say, it's 4 counts, they're all scored.
Right.
Then you get to the seriousness of the offense,
Right.
where you discuss the facts of the particular offense.
Yes.
In other words, if a gun was used in a robbery, it's going to be a higher score than if no gun was used.
Right.
Is that an objective way of scoring?
It's more objective than what the system was before. So I one of the things I've always worked under the guidelines because they were in effect when I started practicing law. And senior attorneys would tell me, and I don't mean senior, I mean, attorneys who have been practicing Michigan sentencing guidelines would say that certain judges used to give basketball scores, meaning that, double digits for, maybe it's an offense where a person should go to prison, but maybe not 40 years.
They didn't care. They'd send somebody to jail for marijuana sales and distribution, give them 20 years, and another judge would give them probation.
Right. And so the law recognizes that was not a fair system, and it was an attempt to make it sort of objective.
Okay, in terms of the objectivity, I was talking about an assessment of the particular crime.
Yes, okay.
Can you argue about the score with the prosecutor in terms of the elements of the crime that must be established for giving a particular score, where there could be a variance of, say, 10 or 20 points?
Right, and that can make the difference between a jail sentence, a prison sentence, or probation. So oftentimes you find yourself arguing with prosecutors. I choose not to argue with prosecutors. If we disagree on something, the proper forum for that is to take it in front of the judge. Even it's just, and the judge will, there entire books that talk about whether or not a particular point should be given for a particular type of conduct. So it's very nuanced. So yes, you have that opportunity, and that's one way that a lawyer can change the sentence. They can advocate for you even all the way up to up till the point you're sentenced.
Now, we've reached a point where you've advocated on behalf of your client. You've dealt with each specific element of the crime. You've come up with a score. The prosecutors come up with a score. You've gone in front of the judge. The judge has assessed the facts, and he or she has made a determination as to what the score should be.
Yes.
Then they come up with a minimum and a maximum amount of time for the crime, correct?
Right, that's right.
The Michigan Supreme Court has thrown a monkey wrench into this,
They
haven't
have.
they?
They have.
Tell our viewing audience what the Michigan Supreme Court has done recently and throwing a monkey wrench into this whole process.
They essentially did what the federal court did probably about 5, 6 years ago. They said that the Michigan sentencing guidelines were no longer mandatory, that they were only advisory, meaning that that the court should look at them, they should think about them, but they no longer have to follow them. Prior to this ruling, the court, if they wanted to depart, either up or down. When we say depart, we mean give a sentence lower than the suggested guideline score or above the suggested guideline score. They would have to have a substantial and compelling reason. And a lot of people think substantial and compelling reasons are, I've been employed for 5 years. Well, no, it's, it's a little bit more than that, that the guidelines have not considered. And it's very tough to get a departure. Now, the court doesn't necessarily have to do that.
And that's because of a constitutional issue that was raised. Is that correct?
That's correct.
And what was that constitutional issue?
The constitutional issue was that it was not fair, right? And so this case, the case that we're talking about, I can't remember the name off the top of my head, but they argued that it was constitutionally, it sort of bound the court and made a decision about what should happen to the individual without giving them the benefit or the discretion of the judge, if that makes sense.
It was a denial of due process.
Yes.
Because the court was locked in based upon the guidelines for the sentencing. However, do you think the purpose of deciding that case was to give the courts the discretion to deviate going down and not going up in the sentence? That's my problem with the decision. What's your thoughts on that?
Sometimes you have cases that change the law and you think it's going to have one impact, but it really is a case-by-case basis. And I've seen judges, so far, it's not helped. It's not helped, change the circumstance of my clients, because most of the judges are used to following the guidelines. And if they see something really egregious, then they no longer feel bound to follow the guidelines. So it's sort of been working against criminal defendants thus far.
In other words, if they look at the gravamen of the offense, when you said egregious, if somebody is involved in a felonious assault, they're hitting a person with a ball-peen hammer, they know it's intentional and deliberate and willful on their part.
Yes.
Otherwise, they wouldn't be whacking them with the hammer.
Yes.
So the judge is going to be more likely in that case to go beyond the guidelines for felonious assault.
Right. Or you have judges who have seen that a person has a record. They may have a gap in between their latest offense, and there may have been a lot of time between the last offense, but the judge just does not think the person is getting it. And so this is a person who might have been able to stay out of prison or incarceration, but because they no longer have to sort of give a reason why they're going to send this person to prison and justify it, then, they do. So.
But isn't it important for the court to articulate, in other words, to state on the record why they're deviating from the guidelines?
It is, and most of the time they do, but sometimes prior to the ruling, they're stating on the record why they're deviating.
Yeah, the court's giving a reason why they're not following the guidelines, correct?
Right, but it works two ways, because they also, when a court deviates, if they go above the guidelines, they have to have a reason for it, and it has to be substantial and compelling. As a defense attorney, I tend to think about trying to, mitigate some of the circumstances, and the deviation I'm often asking for is below. But now, their justification doesn't have to be anything that meets that legal definition of substantial and compelling. It could be something that historically the guidelines already accounted for, therefore the judge couldn't consider it in upping the sentence, like a person's record, So So they're not supposed to deviate for that, right? But they could say you've had 15 contacts, and so I'm going to give you prison time, right? So in that regard, it doesn't help,
Okay, when you say contacts, it doesn't necessarily mean convictions.
right?
And that's another issue. Do you think that individuals who were arrested should have a right to have their arrest expunged from their records?
I do. And oftentimes, if something is dismissed and it's not a conviction, it's very important that at the end of that, whatever that hearing is that results in that dismissal, that they ask for a return of their fingerprint and arrest card for that offense.
And they're entitled to have that, aren't
They're
they?
entitled to have that.
They're constitutionally entitled to have that.
And yes, and they must follow up because it's an order by the court instructing the arresting agency to remove this arrest and the fingerprints associated with that arrest from the record.
Well, thanks for coming today. Thanks for listening to Law Power Hour. And thank you for coming today and being with us.
Thank you for
It was
having
a
me.
great show.
Thank you.